Okay, good evening, ladies and gentlemen. Let me welcome you to today's lecture at the Käte Hamburger Center for Advanced Study, Law as Culture. First of all, I am sorry to say that Professor Gebhardt was not able to be present today. He informed me yesterday that unfortunately he has not yet recovered from a bad flu, so he cannot be with us today. But he sends his best regards, and we all wish him a speedy recovery. However, this gives me the chance to present to you today's speaker, Professor Francesca Caroccia. And it is with great pleasure that I do so. But before I will introduce her, let me just mention that contrary to an earlier announcement, the lecture by Professor Noguchi will not be held today, but it will be postponed, and we will listen to that later, have the enjoyment of that later on. Okay, but now let me first introduce Professor Caroccia. Francesca Caroccia studied law at the University of La Sapienza in Rome. And in 2004, she obtained her doctoral degree at the Faculty of Law of the University of Molise. Her dissertation was entitled L'interpretazione del contratto di principi unidroit di contratti commerciali internazionali. I left out the subtitle, though. Subsequently, she has been practicing law and, inter alia, acting as assistant of former President Amato in the Italian Parliament, consulting in bioethics and European private law, and later acting as legal advisor to the Italian Minister of the Interior. Since 2008, Francesca Caroccia is adjunct professor for private law at the University L'Aquila. There she is teaching private law, commercial law, comparative law, as well as recently legal methodology. Previously, she has also taught at the University La Sapienza in Rome, family law, at the Faculty of Sociology, and lately tort law for the program Master in European Private Law. In 2009, Francesca Caroccia was a guest professor for international law and competition law at the University of Toulouse. Now let me just mention some of the outstanding rewards. She is member of several editorial and scientific boards. For example, especially the editorial board of the Revue Droit et Société, the International Review of Theory of Law and Juridical Sociology, as well as the member of the editorial board of the collection Jus Europeum e Sistemi Italo-Francofoni. Also, I would like to mention the member of the scientific board of the Consiglio dell'Ordine degli Avvocati di Roma, where she is responsible for family, children, and immigration. Professor Caroccia has extensively published in various fields of private law, especially in contract law, also in commercial law, comparative law, and legal methodology. Since July 2013, she is a fellow here at the Käte Hamburger Center for Advanced Study, where she is working on a research project with the title, The Use of General Clauses in the Age of Globalization, the Role of Judges and Political Choices. And this is precisely the title of her lecture today here. Francesca, we are very much looking forward to your presentation. Thank you.
Thank you. I will not take too much time, but before starting my speech, I would like to express my warmest thanks to all people that I met during my first day in Germany. First of all, thank you to Bernard and to Raja, who are not present this evening, but are present in spiritu. Thank you to Nina, who accepted to present my lecture wonderful way. Thank you all people who work at the center, who work with me every day during my stay, and thank you to other fellows who were my school friends. Thanks for everything you have taught me. Thank you for being my point of reference every morning when I arrive at my office, and thank you for everything you have done. So, as you know, the title of my lecture is The Use of General Clauses in the Age of Globalization, the Role of Judges and Political Choices. General clauses at 6 p.m. I hope you will appreciate my work, but in any case, I'm sure that you will sleep as a child tonight, because a lecture on my topic at the time is a recommended method to sleep. So, let's start. Background. I will deal later with the matter of the definition of general clauses, but for the moment, in order to make understandable my speech, I can say we will speak about vagueness in law in general, okay? In particular, general clauses are, for example, good faith or public order or reasonableness. I could say in a certain sense, my end is my beginning, because my interest on general clauses was born as I was working on my first book about the interpretation of international commercial contracts. During my studies on this topic, I noted that a very big place was reserved to general clauses, in particular clause of good faith and clause of reasonableness. And more precisely, good faith and reasonableness were especially used in international soft law instruments as unidroit principles or principles of European contract law. That was a little bit strange, because the use of general clauses is not recommended in international commercial contracts. General clauses increase a big risk of misunderstanding, so generally their use is very limited in commercial contracts, and especially in international commercial contracts. So I started to investigate this topic in order to explicate why general clauses have so big importance in international commercial contracts, and how judges interpret general clauses in a globalized context. This is also the reason why my research is about a very large topic, but in a very specific perspective. I think it's necessary to clarify that I study general clauses from the point of view of private law. That means that, for example, I excluded the constitutional perspective or the criminal law perspective, because there are arguments which request specific answers and specific attention. So, definition. The first step of my research is obviously I try to find a definition of general clauses, but I don't have a good and definitive answer for this question. We still don't know what exactly general clauses are. I could say that almost any author provided a different definition of that concept, depending on the theoretical framework. In general, we could affirm that general clauses are a technique of regulation characterized by producing rules which have high degree of vagueness. Scholars classify as general clauses, as I have said, for example, good faith, reasonableness, public order, equity, fairness. But this is the only side of the problem jurists agree on. There is a long tradition of reference made to legal principles, which is usual to date back to the Austrian Civil Code of 1811. But principles, general principles, are not not exactly general clauses, as we will see later. So as regards to the specific problem of the general clauses, we can affirm that the expression Generalklauseln was used for the first time in a modern and in a technical sense by German scholars. From this point of view, Italian and French authors practically limit themselves to recognize German studies. You can see, in Italy we have practically a literary translation of the German expression. In France, the situation is a little bit different. They have clause générale, the expression who corresponds to Generalklauseln, but they don't have Ventilbegriffe and Sicherheitsventile, and they talk about flexible droit, but the sense is a little bit different. The French attitude to the problem is a little bit different from the German and the Italian one. I don't have the time to talk about that. Probably later during the discussion we can point it out that. The interest of German doctrine on the problem of general clauses was born already in the second half of the 19th century. In 1879, for example, a scholar, Zittermann, introduced a distinction between reine Rechtsbegriffe and Ventilbegriffe. The first expression was used to define open concept, but related to the legal system. The interpreter could find the meaning of a reine Rechtsbegriffe only into the limits of the legal system concerned. On the contrary, according to Zittermann, the meaning of Ventilbegriffe can be found only by referring to exact sciences, or in any case to non-juridical sciences. By this way, Zittermann emphasizes one of the main characters of general clauses, the link effect. That means the property of general clauses to link a juridical norm with a non-juridical one. In this case, with a scientific norm. However, according to Zittermann, the semantic universe of Ventilbegriffe is usually limited to typical notion of scientific disciplines. This is the principal limit of that theory. On the contrary, we use the expression Ventilbegriffe to guarantee to the legal system a relationship, or if you prefer, a way of communication between the legal system and culture in a more large sense, not only exact science. This is particularly clear when you talk about, for example, good faith or public order, or in Italy, buon costume. It's a self-evident truth that these are concepts who could be defined not only by referring to exact sciences, but also to values. This last profile, this link between law and values, law and social context, is more evident in another work of the beginning of the 20th century, in a book titled Das juristische Denken, Wurzel affirms that in every legal system there are theoretical tools who have the function of conferring a certain level of flexibility to the same system. I quote, I define them Ventilbegriffe because they are a sort of Sicherheitsventile. In this last study, is more clearly showed the function of general clauses to open juridical system to social context. Unfortunately, I have no time to analyze every single definition that I found, no reasons why I agree or disagree in each case. I can only specify that I prefer the expression general clauses because it's very common, very understandable in different countries. Above all, after a publication in 1933 of a very famous book, the Flukte in Generalklauseln, by Edelman, we will speak about later. And I agree with theories which confer to general clauses a social dimension. general clauses as instruments to allow the judge to interpret the case in the light of juridical and social values. So I adopted this definition. General clauses are part of juridical rules, which contain references to undeterminate concept in order to confer to the legal system the necessary flexibility and to complete the juridical dimension with axiological references. But it's necessary to point out, until now, that general clauses are tools to complete the juridical dimension with axiological references, but they are no values in themselves. They are instrument too, but no values in themselves. So, my thesis. I will define immediately my thesis as regards the problem of general clauses in order to be as clear as possible. First of all, as a premise, I think the problem of general clauses is not only or not completely or not actually a juridical problem, but a political or better an ideological one. The choice of whether using or not general clauses and the way to use general clauses doesn't depend on general clauses in themselves, but on the political context, institutional framework, and personal attitudes of judges, as Alexis showed. As I will try to demonstrate, there are historical examples which show how the same general clauses can be applied or not applied, depending on the particular political situation. So in a certain sense, from a juridical point of view, the argument of my research has a sort of a natural limit. Jurists can suggest solutions, but the real choice depends on other factors. Having said that, I define my position as a balanced positivism. I think in civil law system, at least, the interpretative process should be carried out in a prefixed and precise normative framework. The solution might not be the same in common law system, where the role of judges is different because the institutional framework and the division of power is different. However, as regards the civil law countries, I think it is necessary a clear distinction between interpretative function of the jurisprudence permitted and creative function of the jurisprudence, that is law-making function, which is interdicted in our countries. What I say requires two clarifications at least. First of all, we know that every interpretative process is also a creative process, in the sense that interpretative process creates significance. From this profile, also in civil law countries, we speak about a creative function of jurisprudence. But there is a relevant difference depending on whether we consider or not jurisprudence as a source of law. The hermeneutical process contains in itself a physiological element of creativity, which depends on the problem of the vagueness in language in general. Every judge, when interpreting a rule, has a sort of free space, but that space is determined with sufficient precision by the law. We can use the X metaphor of a core and periphery of meaning. You know, the concept, every concept has a core of meaning where the application of the rule is clear. Outside the periphery, the non-application of the rule is clear, and here you are the free space for the judge, where the application of the rule is questionable. However, when we speak about creative function as regards general clauses, we affirm something different. We affirm that the judge can create the norm outside the limits of the positive legal system concerned. This type of solution could have many advantages, for example, in order to confer to the contractual system an equitable dimension. However, it may give rise to uncertainty of law and contradict the division of power. When judge creates a norm, it chooses values of references outside the legal system, maybe in the society, maybe in his personal opinion. And the problem is not only the risk of arbitrariness. For me, the real problem is that in this way, the choice of the values of reference is assigned to a subject who has not the political responsibility of that choice. This is the real question, and this is a political problem, not a juridical one. But I say general clauses are instruments which links legal system with social values, and I define them as tools with axiological contents. So maybe it is a contradiction in my reasoning. Obviously, I think no. The fact that the judge cannot choose the values outside the legal system doesn't mean for me that the system is closed. There is a specific place for social instances and for the culture of the context. This is the reason why I talked about balanced positivism. The judge must apply the law, but this duty has to be seen in the frame of the new system of sources of law, which is not the traditional one. The new frame of sources of law is more complex than the traditional one. You see, we have the Italian constitution, the French constitution, the German constitution, but also, for example, the European constitution, or something like that. The new frame of, and in this frame, values are expressed and have to be searched. So I think faced to general clauses, judge can exercise his discretional power, but this power is not a complete and absolute freedom to integrate the law, but it is only the possibility to understand the complexity of the real life and consequently the possibility to adapt norms to facts. In particular, in the modern system of sources of law, constitutions have a very relevant place. As regards the specific problem of general clauses, constitutions play a role of filter. That means constitutions make connection between juridical and social dimensions because they express values of reference of a certain society in a certain moment. In this perspective, judge has to interpret general clauses taking into account constitutional values, but he is not free to choose and to select whatever type of values. By this way, he remains in a juridical dimension, but this juridical dimension includes social values, as they are filtered by constitutions. What I didn't do. In the following step of my research, I fixed the limits of my work. As I have said, general clauses are a very large argument, and it's necessary to determine which exactly my area of interest is. First of all, my work is not a philosophical one. The question of vagueness in law is also a more general problem, who involved the question of the precision of technical languages and more specifically the question of the degree of precision of the juridical language. Those subjects are investigated above all in the perspective of the philosophy of language, but I didn't investigate this profile for two reasons at least. First reason is that I don't have sufficient competence to investigate this philosophical profile. I'm not a philosopher. The problem of vagueness of language, in our case of a juridical language, is obviously linked with my argument, but I can only use the results obtained from other researchers. The second reason is that as a jurist, I can't agree with the philosophical idea that in a certain measure, vagueness is an inevitable element. Naturally, there are different opinions about this problem, but the idea of the vagueness, the irreducible vagueness of language is very common among philosophers of law. there is a very long tradition which teaches us that a word could have an indefinite number of possible meanings. However, in a juridical perspective, I have to take into account the impact of vagueness in law. And as a jurist, I have to suppose, I must suppose, vagueness should be avoided whenever possible. Legal systems are based on the presumptions that norms have a sufficient level of precision. And when judge has to interpret law, he has or should have a limited choice among a few number of possible meanings. For example, we can quote the principle of legal certainty in Europe, but also in the United States, you have the vagueness doctrine in constitutional law. Probably the difference depends on the presence of two ways of reasoning, following different logic with different aims. In any case, my study is not conceived in a philosophical perspective, and it is based on the presumption of the sufficient level of precision of the juridical language. In other terms, as I have said, I can agree with the idea that all language terms and concepts are vague, and consequently law never reaches absolute precision because language in itself requires interpretation. But I have to suppose that law has at least a sufficient level of precision. So in the case of general clauses, we talk about a different level or a different type of vagueness. The second limit of my research is a geographical one. I've analyzed the debate on general clauses in German, Italian, and French law systems in order to compare different solutions to the same problem, but I have chosen to exclude English and American law systems. Obviously, general clauses exist also in English and American legal system, but in civil law countries, the discussion on the topic was developed in a particular perspective. There is a long tradition in civil law countries of reference made to general clauses. That difference could be probably explained in the light of common law jurists' familiarity with the idea of the discretional power of or creative power of judges. The influence of positivism was not so important in common law system, or at least the influence of positivism in civil law countries was bigger. In other terms, common law jurists found relatively easy to accept the idea of a creative function of jurisprudence. The consequence is that civil law and common law countries have often a different way to approach the same problem, so I choose the all-European perspective. Third limit is linked in a certain sense. The problem of general clauses could be studied in two different perspectives. I could choose to investigate general clauses as a technique of regulation, or I could choose to investigate the same problem from the point of view of the meaning of general clauses, of the contents of general clauses. The first perspective is very common in the United States. In general, American jurists used to work in a conceptual framework which is limited to the contraposition standard against rules or principles against rule. The works of Dworkin, for example, are very important from this point of view. This contraposition could be based on two different backgrounds. On the one hand, I could say there is a structural or better a functional difference between principles and rules. This is Dworkin. On the other hand, I could say there is not structural difference, but a difference of degree between standard and rules. Standard and rules would be not different in themselves, but would have a different degree of vagueness. In any cases, in both perspectives, I consider the idea of vagueness in law is not a problem in itself. Current studies show that from a theoretical point of view, principles and rules have practically the same number of advantages or disadvantages. The only problem is to establish the optimal level of vagueness of a norm in a specific cases, considering a series of factors, so for example, costs of transaction or legal certainty, etc., etc. So the discussion is developed in order to find, in each case, the better technique of regulation, more open or more closed. This perspective is not absent in civil law systems. In Italy, we had a very large debate on that argument at the end of the 70s in order to give the legal system a high level of flexibility and a better capacity to answer to social problems. But also in last years, in Europe, there is a large discussion in order to find the better form of regulation to construct a common juridical system. We talk about principles of European contract law, principles of European family law, and in an international perspective, unidroit principles on international commercial contracts. So this is a very relevant problem, but for the moment it is not the subject of my research. First of all, because as I have said, this is a question of technique of regulation. While the problem I investigate is the content of general clauses. And secondly, because I think there is not a complete coincidence between principles or standard and general clauses. I think general clauses are part of the largest category of general principles. I mean, general clauses are principles, but principles are not only general clauses. So, we can define general principles as general norms who have an high level of vagueness or which include a determinate legal concept. And as you can see, this is the same definition that I used for general clauses. So, from this point of view, general clauses are principles. But I can use the same expression, general principles, also for very general norm in the sense that it regulates a case whose relevant characteristics are very general. Or principle in the sense of a norm which expresses the superior values of a legal system. For example, the principle of solidarity or the principle of equality. Principles in the sense of a policy or programmatic norm. For example, the Italian constitution guarantee to citizens the right to health. And principles in the sense of regulae juris quae iure omnes gentes utuntur. That is, norms who are not necessarily vague, but who are certainly the expression of a general opinion in a juridical context, a synthetic representation of the legal system or of a part of it. For example, the principle iura novit curia. I study only a little part of the problem. So, fourth step, function, which is the real function of general clauses in a legal system. Current studies ascribe at least 3 functions to general clauses. A function of reception, traditional function. General clauses refer to social norms which are not juridical norms but are applied by judges. A function of transformation. This function emerges in absence of stable social norms. General clauses don't recognize social norms, but rather social values. The consequence is an increase of judges' power. And a function of delegation. Judges not only express evaluations which they consider corresponding to social values, but they also make economic or political choices which they consider corresponding to juridical values expressed by the legal system concerned. As you can see in the above mentioned analysis, general clauses are always linked with social norms or social values. General clauses overstep the juridical universe to join the social context. In that sense, general clauses ascribe to legal system a capacity to establish a dialogue with social and cultural context, a link between two different logics, a social one and a juridical one. However, at that point, the problem is how to allow that dialogue between different logics. The traditional way to conceive legal systems is very closed, above all in positivist legal systems. In traditional construction, or better, in positivist construction, for example in Hans Kelsen, juridical logic and social logic are separated, and there is no possible communication between those different areas or different logics. The only way of communication has not a dialogical dimension, but a dimension of subsumption. A dialogical dimension presupposes that two parties of a dialogue are at the same level. On the contrary, what I call subsumptional dimension presupposes that one of the two terms of the relationship subsumes the other one. Traditionally, positivist legal systems are conceived in a subsumptional dimension, in a subsumptional logic. I still quote Kelsen. For Kelsen, social context can communicate with law only when social rule is subsumed in a juridical norm, and vice versa, law communicates with social dimension only when law is considered as an element of the context to be analyzed by social logic, but they are not at the same level. So when doctrine affirms that the function of general clauses is to create a link between juridical system and social rules, it's necessary to specify in which sense we will consider that link. In a traditional way, subsumptional logic, or in a different sense, dialogical logic. Statement of the problem. The following step of my work is the analysis of the relationship between general clauses and positivist legal system. As I have said, general clauses exist in every legal system. However, only in positivist legal system, general clauses become an opportunity and a problem. On the one hand, they are an opportunity because they are important tools to grant the legal system the necessary degree of flexibility. From this point of view, general clauses have a positive effect in order to adapt norms to facts, which means in order to make a better answer to the concrete problem the judge has to solve. An Italian author defined them respiratory organs of the legal system. So general clauses are used to grant the legal system a sufficient degree of elasticity, capacity of adapting to circumstances, and they are necessary to introduce some softness among fixed normative elements and to control unforeseen events. And this is more necessary where and when the legal system is a positivist one. But in civil law systems, general clauses become a problem also. They betray legal positivism, which traditionally requires a complete and closed legal system. Furthermore, they ask judges not only for applying laws, but also filling the meaning of a norm. So they request to refuse the idea that jurisprudence has only a declarative function. They represent for legal system a big risk of politicization for Hitler. In this sense, the real problem is not general clauses in themselves, but the use of general clauses by judges. The role of the judge in the legal system, because it becomes necessary to choose between declarative function and creative function of jurisprudence. Also from this point of view, the choice between principles and rules is essentially a political one. Today we could find outdated the opinion that the interpreter and judge in particular has only a declarative function. Such an opinion is obviously a consequence of a strict positivist attitude On the contrary, today most authors prefer to admit that judicial function fundamentally is an integrative and discretional function, also in civil law systems. But the problem at that point becomes to establish the level of the discretion admitted in every law system, in every legal system. So, risk analysis. General clauses request that judge makes an operation of construction and at the same time an operation of evaluation, but both to be made by recurring to external parameters. These parameters could be juridical or non-juridical, but in any case they reflect the historical and the social context in which the judge works. The problem is how to reduce the risk of arbitrariness when the judge uses those parameters. I can affirm in civil law countries the trend is a juridification of social parameters in order to reduce that risk. I mean, the trend is to connect the social parameter to a juridical norm. If we try to represent the way general clauses are used in a model, we can note that the itinerary is not linear. It can be shown as a sinusoidal curve, not so precise, but more or less. In the first time, positivist legal system must introduce general clauses in order to guarantee their own existence. But judges refused the power which the system conferred to them. Judges practically ignored the use of that instrument during the 19th century. In a second time, we are more or less at the end of the 19th century, second half of the 19th century, interpreters discovered general clauses. What happened? From a theoretical point of view, European doctrine discovered, or even better, rediscovered, the social dimension of the law, the complexity of normativity. We can quote, I don't know, Genie, Saleil, the Freie Recht Schule, Interesse in Jurisprudence. From a practical point of view, in the first half of the 20th century, after the war, there was in Europe a terrible economic crisis and consequently currency devaluation. And it's very interesting to analyze the reaction to the same problem in different positivist countries. Italy and France confirmed their positivist approach. Judges ignored the problem of devaluation, and applied the principle of the monetary nominalism, even if the consequences were manifestly non-equitable. You understand the principle of monetary nominalism? More or less, it's 100 marks is 100 marks. No? Even if you can buy only a coffee with 100 marks. On the contrary, the reaction of German jurisprudence was very strong. Judges applied the principle of good faith to the case, and they introduced an exception to the monetary nominalism. In some cases, they come to expressly deny that principles in the name of the good faith and in the name of the interests of the parties. The practical consequence was really important, a general revaluation of credits which had been stipulated before the war. But German doctrine doesn't completely ignore the dangers of that way of reasoning. I above mentioned a book, Die Fluchte in die Generalklauseln, by Edelman, and in this book, Edelman, in 1933, and the date is very important, shows the possible negative effects of the use of general clauses. Unfortunately, the opinion of Edelman was correct. In the following years, the Nazis used general clauses in order to affirm, for example, the will of the Führer. General clauses become the main instrument to adapt the legal system to the new political aims. It's very famous, the case in which using general clauses a valid contract was declared void because one of the parties was Jewish. However, it is necessary to be more precise on this point. The attitude of the Nazism, or the fascism in general, toward general clauses shows a contradiction. On the one hand, the Nazism was a sort of golden age for general clauses. The Führer was the interpreter of the zeitgeist. So law had to be interpreted following the will of the Führer, and general clauses become instruments to allow this process. But on the other hand, the law is the expression of the will of the Führer. There's no space from this perspective for in the hermeneutical process for exterior elements. So the consequence of the fascist ideology of the 30s and 40s, which sustains and informs the German legal system and the Italian legal system, was a very strong positivist attitude. This is really a contradiction. Interpreters refused every reference, for example, to natural law or to the ratio, you say ratio, in Italy it's ratio, of a norm. This is the reason why, for example, in interpreting racist law, they can use reference to natural right, natural law. They must apply racist law. I think this historical example shows very well that the real problem, as I have said, of general clauses probably is not the clauses in themselves, but the political trend and above all the cultural context in which general clauses have to be applied. The reaction after the end of fascism was the closure faced to the general clauses. However, at the end of the 60s, there was a new interest for that subject. The question was if, in the new democratic context, interpreter could use general clauses to introduce ethical instances in the legal system. Today, when he has to apply a general clause, judge could have four options. First option, he can connect the meaning of general clauses to other juridical norms to the same level in the pyramid of sources of law. By this way, he only apparently uses general clauses, but really applies to the case a juridical and specific rule which already exists in the legal system concerned. For example, he mentions the good faith principles to establish the duty of a party of a contract to do something in favor of the other party, but this obligation is already previous in the law of contract. That means, in this case, the use of general clauses doesn't really make sense, is neglected. Second option, he connects the meanings of general clauses to other juridical norms of superior level, that is, constitutional level. In this case, he always connects the meaning of general clauses with juridical norms, but with regards to the constitutional system. By this way, he can use general clauses in a more open way, more directly connected with social values, if I presume constitutional values are the expression of values accepted in a certain moment in a determinate society. The second option is very common in civil law countries that I consider. Italian, French, German doctrine emphasizes the importance to connect the meaning of general clauses to constitutional norms. I can quote the opinion of Zimmermann, but also German Constitutional Court, for example, has expressly affirmed that general clauses are Einbruchstellen, which means a breach in the wall, an open door, between private law and constitutional law. That method allows judges to be free and establish a link with social and cultural context, but it fixes a clear frame for them at the same time. It's probably the better way to use general clauses, but at the same time to respect the guidelines of positivism. But note that the hermeneutical circle is still limited to the juridical dimension. Third option, the judge can connect the meaning of general clauses to other rules expressed in similar cases, jurisprudential rules. In this case, rules expressed by judges in applies general clauses are organized by groups in order to create a sort of a rule of precedent, which reduces the discretion of the judge. The judge could introduce an exception to the jurisprudential rule only when he thinks that the case concerned is different from precedents. Regarding this third option, the example of Germany is very important. Also in Italy and in France, precedents have a big importance to define a case, but the German solution is different. German doctrine uses to classify cases in which judges have applied general clauses in order to categorize its various fields of application and to establish typical groups of cases, and they call those groups Fallgruppen. The question is if the construction of groups of cases might be in contrast with the natural attitude of general clauses to be tools to find a better solution in a specific case. On the contrary, the Fallgruppen practically become norms with the same level of abstraction or generality of a norm. This is a way to control and to reduce the power of a judge, obviously. And in some cases, one of the Fallgruppen has been translated in a positivist norm. For example, the case of the Geschäftsgrundlage. It's a sort of circular itinerary, always conceived in order to restrict the space of creative power of the judges from general clauses in the civil code to Fallgruppe to positivist norm of the civil code. The aim to control the discretion of jurisprudence is evident. Fourth, the judge can connect the meaning of general clauses to social parameters, not juridical or not yet or not directly juridical parameters. This is the solution which attributes the highest level of freedom to the judge, and probably this is the most coherent solution with nature and function of general clauses, but it's also the most dangerous for legal certainty. I noted that solution is usually adopted when reference to social parameters means reference to technical standard, to measurable parameters, or when reference to social parameters means reference to very shared and accepted cultural standard. What I mean in the first case, technical standard, for example, when judge can ask to a psychologist which is the best interest of the child in a particular situation. The second, measurable parameters, is reference a reasonable time, for example. And in the last case, for example, in Italy, best interest of child until 15 or 20 years ago, the meaning of that expression was the children must stay with his mother. And this was a very common way of thinking, very shared from a cultural point of view. Last step. The analysis of risks show that in a national context, in positivist legal systems, the much shared solution to reduce the risk of arbitrariness is considered to establish a link between general clauses and shared or juridical values of the legal system concerned. More precisely, wow, the best solution to reduce the risk of arbitrariness taking into account social context and necessity of flexibility, is considered to limit the discretion of the judge by reference to the constitutional principles and values. By this way, the contradiction between positivism and general clauses could be solved or could be reduced at least. However, in the age of globalization, it is necessary to enlarge the national perspective, taking into account the effects of the globalization on the use and signification of general clauses. In the globalized context, the problem is to determine new standards of evaluation. So the new question is, what happens when the context changes, when the judge has no traditional points of reference? And how can he identify the evaluation standards? In absence of a particular system of values, in absence of a constitution, the meaning of norms and general clauses only resides in the discretion of the judge. In this perspective, the risk is that the judge gives political answers or that the market logic imposes its rules without any possible control. During my research, I analyzed how general clauses act in a globalized context to verify how judges use the discretional power that general clauses grant them in order to find solutions able to reduce the judge's discretion. I've analyzed all cases concerning international commercial contracts published in Unidroit website and Italian and French law reviews. And traditional thesis is that in private law, general clauses are instruments used by soft law to limit private autonomy, to make private bargains fair, reasonable, or at least more balanced. On the contrary, my thesis is that in the globalized context, general clauses are used to allow the market logic to govern or at least to influence the juridical area. Sometimes the effect could be positive. Sometimes this process corresponds with more fairness in the contractual relationships. However, in a general way, in the world of trade, both at the national and international level, there's no space for ethical evaluations, for solidarity. More often, the aim of legal interferences is to guarantee the respect of the market's rule and a correct development of trade.